Attorney Nate Amendola, criminal law in plain English. The question today is, can charges be dropped after an indictment? And in plain English, the answer is yes. Let's unpack this a little bit. First, let's understand what an indictment means. All cases in Massachusetts, including murder, start at the district court. The district court is the lowest trial court in Massachusetts. It hears all misdemeanors, and, well, I should say, it has final jurisdiction, which means it can hear the entire case of all misdemeanors and some felonies. There are some crimes, many in fact, that are so serious that they can only be heard in the Superior Court. Think rape and murder. So what that means is a case it will start in the district court. That's where the first arraignment will be. Maybe even a couple pretrials, and then if the Commonwealth wants to move forward with that case, it needs to do an indictment. Well, I should say, the Commonwealth needs to get the case moved over from the district court to the Superior Court, and there's two ways to do this. Number one, there can be what's called a bind-over hearing or probable cause hearing, which is rare these days, although we'll talk about that in another video. But that's a hearing, almost like a mini trial, at the district court where there could be or will be witnesses and other evidence, and the district court judge will be determining whether the prosecution has presented adequate evidence, and the standard to evaluate this evidence is just probable cause. So the judge will be looking to see if the Commonwealth has established probable cause to bind the case over to Superior Court. And in other words, probable cause that the elements of the offense are met, to bind the matter over to Superior Court. Or the other way a case can get over to Superior Court is the Commonwealth convenes a grand jury, and that grand jury, basically the same function as what would happen in the district court at a probable cause hearing, although different in that the defense is not present during this grand jury proceeding, but there's a number of grand jurors in the room, and the Commonwealth brings in some witnesses and presents evidence to the grand jury, and then the grand jury takes a vote. And if the grand jury takes a vote to indict, an indictment is handed down. Then the defendant, there'll be a new arraignment. The whole thing starts over again in the Superior Court. But getting back to the initial question, can charges be dropped after an indictment? Well, yeah, of course they can. There's nothing preventing charges from being dropped at any stage in a proceeding. But as you can imagine, if the Commonwealth goes through the trouble of either a bind-over hearing or what's sometimes called a probable cause hearing, which again is somewhat uncommon these days, if they engage in that activity or if they go through the trouble of indicting somebody, I think you could imagine that they've thought really hard about whether and what types of charges and what counts they're looking for. So yes, things can be dropped by the Commonwealth. Remember, it's only the Commonwealth that can drop charges or dismiss charges, really, absent a motion to dismiss proffered by the defendant that says that there's some problem with the criminal procedure or some sort of evidentiary deficiency or something like that. But the Commonwealth is the only one that can drop the charges, and they can drop them after indictment, and sometimes they do in contemplation of a plea. So if somebody's got a 10-count indictment, as part of the negotiation, if it goes this way, the defense lawyer or the defense lawyers might negotiate for guilty pleas on 6 out of the 10 counts. And in contemplation of those pleas, the deal is that the Commonwealth is going to drop or dismiss the remaining 4. And that would happen in a change of plea hearing or even at a trial. So yes, in plain English, can charges be dropped after indictment? Yes. Practically speaking, it's a little bit more difficult. It happens most often when somebody is negotiating or executing a plea. But that is how it works in Massachusetts.